Welcome to Small Practice Support Information Session number 68. In this recording, Bill Holohan, Senior Counsel, talks to Justin Purcell about professional indemnity insurance.
You're very welcome to this small practice information session on PII. I'm joined, thank you. I'm joined by Bill Holohan today, who's chair of the PII committee, recently voted as Lawyer of the Year at the Irish Law Awards, and he is listed as one of Ireland's best law firms. So Bill, he's also chair of the PII committee. So Bill, you're very welcome, and thanks for joining us today.
Pleasure. No, I'll have a PowerPoint presentation which will be circulated to everybody afterwards, so nobody needs to keep track. You can nod off if you need to in the middle of it. But I'm going to run through this. There's a couple of the headings that I'm going to look at very briefly and cover. As I say, we'll run through for about 20 minutes and then we'll take the questions in the last 10 minutes or so.
Yeah, if anyone has a question, if you could launch it up on the chat, we'll take it there. We'll be sending out a recording with all of the slides on Friday afternoon. So you're very welcome, Bill, and over to you.
There have been a number of presentations made at the various bar associations around the country by Saoirse Hayes, who's the secretary to the PII committee over recent weeks, and she gave a presentation. So some of the latter end of the slides I'm using today come from her presentation, but I'm not going to repeat everything that she said. The major update since those presentations has been the finalisation of what's called the Participating Insurers Agreement. That's the pool of insurers who have agreed for the coming year to participate in the market. They've signed off an agreement with the Law Society in relation to the minimum terms and conditions, and they're going to be offering cover in the market. Now the slide there says there's one potential new insurer may enter the market. That's been updated in the later slide here now, that insurer is now on board. No insurer will deal directly with the solicitors. You have to go through a broker, and there's a list of all the available brokers going to be flashed up on screen as well. And all this information is as per the detail that's been provided by the insurers to the Law Society. If anybody needs any particular help in relation to their PII and they are having difficulties with brokers or whatever, they can contact the PII helpline, and the number is on screen. There's also an email that they can send through any inquiries. So the insurers who are participating: AIG, that's an A+ rated insurer. You can see the list on the right of the brokers through whom you can put proposals to. AIG, they're generally looking for 3+ partner firms. It's the mid-size to the larger ones. They are not interested in sole practitioners. That said, if you're already with AIG as a sole practitioner or a smaller, say, two-person practice, they will offer renewal to existing clients. Then the second one is Aviva, again AA-, 2+ partners for them, and again it's all the brokers. Canopius, they're an A-rated insurer. They will take sole practitioners and principals and the smaller size firms, and again it's all area insurances you go through for that. CNR Hardy, they are an A-rated insurer again. They're willing to work with all brokers, and they're taking all firms. Hamilton, A-, again, all Lloyd's registered brokers, but they go going for the mid-sized firms up 5+ partners. Liberty, they're an A-rated insurer as well. Generally, they don't go for the sole practitioners. They look for the 2 to 5 size or 5+. And again, there's a list of the brokers there. The main ones obviously being O'Leary's, Lochtons, Millers, Crotty, etc. QBE. Now, as you know, QBE have taken a decision this year that they're restricting their offering to firms that have annual revenue in excess of 5 million. Last year, they cut off a number of people late in the day when they announced that they were going to be introducing a threshold. And that meant that there were a lot of what I call QBE orphans who very late in the day were looking around for alternative insurers at a point in time when a lot of the insurance companies had already written their book. They weren't looking for more business. But it's been clearly flagged this year, 5 million+ in terms of revenue. It's not down to firm size. If you happen to be a sole practitioner with revenues of 5 million over, they'll talk to you. They're chasing the money, and the list of brokers is there. Star, again, A-rated, O'Leary's and Howden and Lochton, and they're open to taking all firms. Allianz have also confirmed they're an AA rated insurer. They're through Miller and Marsh, and they're open to all size firms. The reason they're highlighting yellow there was because they had to get a special derogation in relation to an extension of time for signing the Participating Insurers Agreement. Then there are two facilities, the Allianz-led JLT facility and the Miller facility. And again, they are offering the cover. The big ticket item was that late last week, it was announced that AmTrust International are coming back into the market. A number of practitioners, the smaller practitioners in particular, would have been insured with them in recent years, but they went out of the market for a couple of years. They're now coming back and they're joining the Star Europe Insurance facility led by O'Leary Insurances. And again, their contract details are there. That's particularly good news for the QBE orphans, as I would call them, and the smaller practices. Because there was a substantial number of sole practitioners in particular and the smaller firms who were insured with them in previous years. So the big question, what's my premium going to be like this year? That goes into a number of factors. It's not just the base rate that they're looking for in terms of a return on premium income, but also looks at the risk. And there's a grid there showing all the various factors that feed into it. There are a couple of areas that will affect the bottom line from an insurer's point of view. There's insurer solvency and their profit requirements and the global PII markets. Now, on the global front, over the course of the past couple of years, the insurers have taken a heavy hit. It's affected their bottom line, so they want to try and improve their bottom line. So they're going to raise the premium across the board. In the English market, they had their renewals earlier in the year, and the increases there went from anything to 25% up to 30% in some instances, as a kind of a benchmark in terms of what the rate increases were. The rough rule of thumb is that's likely to be replicated here. So regardless of how good you are, regardless of how many systems you have, you're likely to be facing an increase in a premium. Our premium last year increased substantially, but that was just the way the market is going. The individual items that are set out in blue there are the factors that would influence any individual quote outside of the general bottom rate increase, so to speak, that would come from the insurer's desire to increase their bottom line. So if you can focus on all of these different areas and try and improve your profile, that'll help in terms of the calculation of the premium. You know, as if your profit's gone up, your premium's gone up, depending on the type of work. And if you look at the common proposal form, you'll see that they're asking for detailed breakdowns by percentage areas of the type of work that you're doing. And there's a range of different risk exposures. I'll mention some of these later. In terms of the type of work that is likely to lead to claims. So, for example, conveyancing is regarded as a high-risk activity on the purchase side, not necessarily on the sales side. That's at one end of the scale, so to speak. Trust and estates will be up there as well. At the other end of the scale, for example, things like mediation, of which I do a fair bit amount of work, or criminal work, for example, is not regarded as a high-risk activity. With attendant risk, because it tends to lead to the lowest level of claims. So again, being clear about your type of work and the percentages, that'll influence the potential premium. Your profitability, obviously, as I mentioned, and your practice profile, the number of people you have, and the type of work that they do. As one statistic there, just threw it in, construction PII saw jumps last year of up to 600 in the year. So the construction professionals, architects, engineers, etc., that liability insurance has gone through the roof, if you pardon the pun in construction terms. Accountants as well have seen a huge jump in their insurance premium, in some cases of up to 100%, but it hasn't necessarily translated into the comparable sector for us. In terms of the PII regulations, they're amended this year to just do a clarification in relation to the question of cyber cover. And that is built into the minimum terms and built into your professional indemnity insurance is a minimum level of cover for 1.5 million for cyber cover negligence. In other words, if a client suffers a loss as a result of a cyber attack, and client funds are at a loss, for example, you're covered. If you went to the market to try and get 1.5 million of cyber cover for clients like that, you could not get it in the market. Accountants, for example, wouldn't be able to get that kind of cover. So it's a unique benefit that we as solicitors have as a result of what the PII committee recommended and the council approved in terms of the minimum terms. That said, it does not cover your own loss. In other words, what's called a first party loss. It only covers a third party loss. So if you are hacked and you have to pay a ransom, or if you have your systems are compromised and you have to get new servers or all that, that's not covered under the PII cover. You'll be well advised to take out separate cyber cover. And again, for the potential downside, it's quite a reasonable cost. For a couple of €1,000, you can get full cover for your likely costs that would be involved. Again, talk to your broker in relation to that. So the issues that will factor into your premium, the profile of the practice, the type of work you do, the fee income, the areas of practice, sticking to core practice. There would have been a temptation, for example, during lockdown for people to move outside of the core competence. If somebody is seen to be moving into a new area from last year, the insurer is going to say, well, hang on a second now, you've suddenly decided to get into medical negligence. That's a highly specialized field or whatever. What experience do you have? You know, are you really equipped? Do you have the knowledge? And that might expose a higher risk profile. Your historic exposures, your claim experience, if you have previous claims, they'll want to know what have you done to try and make sure that you don't repeat those claims. Many years ago, I was with the SMDF and had a claim. The following year went to Lloyd's, who quoted less than the SMDF for quoting for renewal. And when I queried, but there was a claim, they said, yeah, but that's never going to happen again. And you've shown us that you've put in place steps to ensure that how that happened could not happen again. Therefore, you're obviously into risk management. COVID-19, working from home, that poses challenges, obviously, if people are accessing the office systems remotely. It's a greater risk in terms of cyber interference and cyber attack. Also the question of supervision. It's one thing to be able to walk into the room next door, talk to an associate or a junior or member of staff and see what they're doing. It's very difficult to do that down a camera. So they will want to know what the systems have been put in place in relation to working from home, file supervision, file review, file management, file audit as well. Because it's one thing to say, Justin, you're dealing with the file of Bill Holohan, and what's happening with that? And Justin says, oh, set down for trial, we're ready to roll, and actually he's forgotten to issue the proceedings at all. So you have to go beyond a mere supervision and general engagement into actual audit occasionally. Again, your risk management accreditation, if you have some external system or external body who are giving you a particular standard, that helps. It doesn't dramatically reduce your insurance premium. You don't automatically get 10% off because you've got one of these things, but it does factor into the overall thing. In terms of conveyancing, just a tip, differentiate between the buy and the sell side. If you sell a lot rather than buying, that obviously is a lesser risk. If you buy a lot, say new housing or whatever, that may expose a potential risk from the insurer's perspective. And again, they'll want to look at systems in relation to your retainer. When you're taking on a client, they'll want to know, do you define clearly what you're going to do and more particularly what you're not going to do? That can be important, for example, in trust and estate work, wills, etc., as to what you are going to do, whether you're going to advise on tax issues. That's a higher risk area. Very quickly, I'm going to show you some slides in relation to LSRA complaints, because complaints feed into ultimately potential claims, and you can see the percentages there. The vast majority relate to the conduct of litigation. That would be delays, etc. Then you have conveyancing coming in as a close second behind it, followed by probate, family, and then down as a low enough for crime, employment, and a mixed bag of other complaints. This slide is taken from DWF, who recently gave, as part of the Solicitors Growth Network, don't mention the competition, a presentation, and this was the basis of a claims experience as to where the claims come from. You can see in the main, Munster and Leinster, followed by Connacht and Ulster to a lesser extent, and then there's a breakdown of the claims, again in a particular claims experience profile. But in the main, it was Dublin and Cork. That's not surprising considering the urban centres. So the nature of claims, 34% relate to, now this is one particular claims handler experience. This isn't necessarily a definitive statement of the type of claims generally, but you can see claims on the litigation side being statute barred. So that feeds into the question of your office systems and controls. Do you have a register for important statute dates? Register of undertakings on the conveyancing side similarly. That type of thing. Then residential property claims, commercial property claims, agricultural property, general debt litigation, breach of undertakings. And again, the insurers want to know what are you doing about your undertakings. They want to look at how old they are, why are they outstanding. It could be, particularly with delays in registration of the Properties Registration Authority over the past year, that there are a number of dealings already lodged and you're waiting until they come back out before you can complete your certificate and return the title deeds to the lenders, etc. You may have claims resting in contract, and some of those could be quite old, and they'll want to know why they're still resting in contract. They'll want to know, have you recommended to the client that they will be completed, that type of thing. So The key questions, and you need to ask yourself before you start filling in the relevant answers on the proposal form. Do you operate a system for recording, monitoring, and reviewing the key dates? What's your supervision arrangements? What's the arrangement for new client vetting in terms of your capacity and your capability, your competence, etc.? There's a temptation to take on new work when there's a shortage of work, but is it outside your core competency area? Are you going to spend a lot of time at the client's expense trying to learn how to deal with things, and could there be risk exposures there? Any disputes regarding undertakings, any complaints from financial institutions in particular, any potential claims as well, circumstances giving rise to a claim. It's important that if there's a circumstance giving rise to a potential claim, that you would notify the insurers. Now, at one extreme, you could say when you send out the bill to the client and the client says, oh, I'm not paying that, you screwed it up, you were negligent, I'm going to sue you. Theoretically, that's a circumstance capable of giving rise to a claim if you notify it. If you notify that level of things, an insurer is not going to say they're a bloody nuisance. They're going to say they're being careful. Technically, they're being correct. You explain, look, this is just a narky client who doesn't like having to actually pay fees. But it indicates that you're very careful about anything that could be regarded as a claim. A number of the cases that I've dealt with from my professional negligence defence side of things over the years did relate to where people didn't understand that there were claims and they didn't notify them, or they thought they could work things through and they didn't want to mention it for fear it would queer the pitch in terms of insurance premium renewals. It's better to disclose, because if you don't disclose, there's a danger they won't indemnify you afterwards if it does turn into a claim. Again, dealing with complaints quickly. One of the major causes for complaints to the LSRA is non-communication with clients. It's no harm as things are happening to copy in the client, say, I've done this, I've done that. In our practice, for example, in the main, it was very rare that we'd actually send out physical letters. The main thing is we'd be copying people in on email and emailing them on updates. It shows activity, it shows you're on top of the file as it's going along. It only takes a second or two, but it can avoid huge explanations to the client afterwards. Again, make sure your office systems are well secured, your firewall protected, all those type of things, they all help. And if your IT providers can provide you with certification in relation to all of this, that'll help to complete the profile. Work with your broker and insurer, make the broker work for the commission, find out what your broker is actually being paid, what slice of your PII premium every year are they actually taking. And again, don't rely on one broker. You'll see if you go through the lists, not all brokers deal with all insurers. Some do, for example, on Aries, who have presented here previously, they deal with all insurers, but not all the brokers do. So you may need to ensure that your proposal is going to all insurers, depending on the broker you use. Prepare early. That's to allow for any questions or queries that might come back. Inadvertently, you might say no to a question in the form when you should have said yes. That may lead to a query. And if that query is coming back on the 30th of the month, you know, you're not going to be able to respond to that fairly quickly, and it could prejudice you. So get it in early, check it, read it once, read it twice, read it 3 times before you send it off. The variable insurance rates or renewal rates, theoretically you can apply for insurance at any time of the year, but the difficulty there is that the insurance companies generally will write their book in December. They don't have any further capacity. So if you go to them in April, say for example that you're trying to set up a new practice, you might find that there's no market there. There's nobody willing to actually offer insurance at that time. Justin was in contact with me earlier in the year in relation to somebody who had that kind of a problem. They were talking about setting up their own firm, but they couldn't actually get a quote because the insurers didn't have capacity on their books. Again, there's the Law Society Finance Scheme that's available for financing your premium, breaking it out over 10 months of the year rather than paying it all in one go. There's all the contact details in relation to the PII. So that was a quick slalom tour of a 1-hour presentation in about 20.
So the question was, who's the new insurer?
AmTrust International. They're mentioned in the PowerPoint, and their contact details are in there. They were in the market for a number of years, then they went out for a couple of years, but they're now back.
Okay, and if anyone has a question, we'll take it on the chat. There's a few observations there just with regards to quotes that they've been given. So they've been offered a quote 34% premium increase, which is, and the reasons they've been given is an 18% increase in fees vis-a-vis last year, and a standard market approach from all insurers this year who are seeking rating increases up between 15 to 20%. In our case, this is 14%. Does that sound right or fair? Or
it doesn't sound right or fair in the sense that any increase is going to be viewed as not being right or fair, but it's consistent with the market generally. And like they've differentiated there, the reason for the increase is your 18% increase in fees, which is great news for you in terms of fees, but as a consequential exposure in terms of the risk profile, and then the general increase across the board, which is back to the base rate point that I made at the outset, that all the insurers are trying to up their premium income because they've had losses in other areas.
Yeah. So there's a query there around cyber insurance. They've been given a quote for sort of a run-of-the-mill type cover, 6 to 7 grand.
I can tell you, we put in place cyber cover this year. We're a 3 solicitor practice, and it was only about 2.5 grand, I think, if I recall the figure correctly. So it depends on the size of the firm.
Okay. So there's a query there also around the Law Society finance rate with Bank of Ireland. They're asking, are they competitive in relation to others? You may not be able to answer that.
I wouldn't have the detail to answer that one.
Yeah, so it's all about the interest rate that they're charging. I'd say shop around, but you might find it hard to get cover or get them to give you the finance. There's a query there about O'Leary's saying that they're brokering for Allianz, but then they said that they don't actually handle them, so we had to go elsewhere. Okay. And it shows that it pays to double check to make sure that you are testing the full market. So here's a question I had was like, let's say you get a quote, but you don't like the quote. So like shop around. Is there a drop dead date that people need to have coverage in place by?
Oh yeah, you have to be insured by the end of the month, and you have to then confirm by early December, the first week of December, you have to confirm your insurance details to the Law Society.
Oh, so it's really something you need to really.
And if you don't have insurance, you will not be able to get your practicing cert in January. Like I'm helping a colleague at the moment who had that difficulty. He literally, his premium went up by a factor of 800% last year, and he wasn't able to afford it. He wasn't even able to go into the assigned risk pool, which is a safety net for people who aren't able to get insurance in the market, but which has restricted terms. If you go into the assigned risk pool, for example, effectively you can't do conveyancing because you can't offer undertakings. And it's literally a kind of just a safety net on a temporary basis, on the basis you try and get back into the market. But if you don't have your insurance in place, you don't get your practicing cert. If you can't offer legal services, you can't get paid.
So what happens in that circumstance if I don't have insurance? Like you've just described that I can't offer services, but should I contact the Law Society? Should I contact the helpline?
Yeah, Yes, and you'll be referred to the ERP in the first instance, and they'll try and help you out. But you know, this particular colleague that I'm helping, he couldn't even afford the ERP premium. Now his circumstances are very unusual and very unique, but it was unfortunate because he had no insurance cover, no practicing cert. No practicing cert can't do things. So, for example, even trying to settle cases that might be right for settling, he couldn't do that with a view to generating some income, which might have given him a pot out of which he might have dealt with the insurance. So it would involve a new solicitor taking over the file to settle it and then giving him the fees in relation to it.
So there's a query there in relation to if I have a heavy work split in favour of conveyancing and probate for sole practitioner. Is this affecting PII renewal quotation? So I think you mentioned during the presentation particular types of work that were more...
Yeah, conveyancing and probate would be regarded as more the riskier end of the market and more likely to give rise to claims. So there, if you can kind of differentiate the type of work that you're doing, particularly between sales and purchases. Sales are regarded as less risky for fairly obvious reasons than purchases. So if you can split down your work ratios in relation to that, and again, probate, defining exactly what you're doing. There is a provision for putting in I think section 16 of the form, additional information. So you could specify there what you're doing, the type of work you're doing. If it's simple mama and papa wills, as distinct from some complex trust arrangements or tax-driven exercises or tax planning, if you can differentiate that, that explains the potential risk in greater detail and will help in terms of the assessment.
So there was a question coming out with regards to risk audits, and risk seems to be coming out of this presentation a lot. Is there any particular forms or sheets or places I can go to access that, putting a suitable process in place, do you think?
Yeah, there's a number of service providers who provide a kind of a risk assessment service, and they'll come in, they'll do an audit on you, and they'll make recommendations, and they can even lead to accreditation. Now, as I say, simply because you get that accreditation doesn't necessarily translate into an automatic 5, 10, 15% reduction. It shows that you're taking the job of work seriously, but you can demonstrate that you have the systems yourself. You know, if you have the comprehensive policies and procedures.
Yeah. So it's better to have it than not have it. I mean, it allows you to demonstrate some competence around it. So here's another question: where is first choice for a sole trader with a very small niche family law practice? Is there a minimum threshold at play for all providers, or if that makes sense?
As Father Jack would say, that'd be an ecumenical matter. Family law, again, it's kind of mid-range in terms of the potential claim profile. You need to talk to your brokers. In terms of companies, there'd be a number out there who'd be willing to take a sole practitioner who would focus on family law. To talk to your broker, don't just send the form to them, have a serious discussion with them.
Okay. So you should note that just a comment, I think there, that you cannot even issue a bill if you don't have a practicing certificate. So maybe we're just coming into the last few minutes of the call, and if anyone has a question, we'll take it on the chat. But we are moving into sort of the end game here. So Bill, if you wanted to sum up what people should be doing right now, they should really have their common proposal form out on the table, and they should be filling it out if they haven't done it already. If they're running into problems, they should be ringing the PII information line. And is there anything else that they should be considering, and maybe making contact with Bank of Ireland potentially to get finance in place?
We're all busy, but this is extremely important. So people should, if necessary, be taking a day out to complete the form. The form, if you're going to fill it out properly, and if you don't have the core information to hand, having to go off and find it, looking back over the past 5 years of accounts, for example, to work out what your turnover was from year to year, what your split in terms of the types of work, the percentage of fees, etc. All of that is going to take you time. So you need to make an appointment with yourself to take that time out. If necessary, take your weekend to do it if you can't afford the time during the week. But you need to be doing that as a priority this week.
Yeah,
I see there that Ross says he sent off his form this morning.
Yeah. So maybe if you for a time management piece is to take a bite-sized chunks of it, do an hour in the morning, an hour at lunchtime, and an hour in the evening, and then you've done 3 hours as opposed to getting into 3 hours of it. So, and do that every day. There's a query there around somebody just only be given covered by CNA Hardy with regards to conveyancing, and they're wondering what can the Law Society do, or what can the PII committee do to bring more insurers into the market? Now, that's a big question.
It is. I mean, and you can see there's quite a number of insurers who have been encouraged, and on an ongoing basis, the work of the committee operates throughout the year. And I have to give great praise to Saoirse Hayes, who's the secretary of the committee, and the staff of the Law Society, who are courting insurers from year to year to try and make sure that they don't leave the market, and that we can get more people into the market. And it's as a result of that kind of work that brought AmTrust back into the market this year. In terms of only option open on this year is CNA Hardy. That's again down to the insurers. Nobody can be forced to provide insurance. This is an open market. All the Law Society can do is set the minimum terms that have to be provided in terms of the cover. The insurers then react to that by saying, yeah, we're prepared to do business on that basis, or we're not. Occasionally, they'll come back from year to year and they'll ask for some kind of a tweak or a clarification. But it's fairly well established what they have to offer. And most insurers are willing to do that. But the Law Society can't dictate terms to any particular insurance company, can't tell an insurance company you must cover somebody. It sets the base safety net level of cover in the minimum terms, and after that it's a question of, is the market prepared to offer it?
I don't think this is a problem necessarily just for the Irish jurisdiction. I think we're seeing this similar type problems in the UK market and for other professions as well, such as engineers, accountants. So it's not just a particular, premiums are going up and insurers are leaving the market.
Yeah. I mean, when you look at the profile of practitioners in Ireland, there's the majority of firms, the huge majority are sole practitioners. But the problem is, from a risk management point of view, that's perceived as being risky from an insurer's perspective. The theory is that if you have two people in a practice, they can monitor each other. And, one is having some kind of supervision over the other. And that's where the kind of the risk profile is all important. And particularly for sole practitioners, I agree. Sole practitioners are under huge pressure, whether it's even 150 compliance now, AML requirements, reporting, etc. The burden of running the business is taking a number of hours a day. let alone actually getting the core work done. And if you can spread the joy among a number of other people, that's great. I labour under the title in our practice, Holohan Lane, as the senior partner, and that's in difference to the fact that I used to have hair and it used to be red, but it's now grey. But my partner, John Lane, who happens to be sitting across the room from me, listening to me, he, in fairness, takes on all the burden of the managing the practice, and he looks after all of these things, thankfully. And we engage on a daily basis in relation to it.
Listen, Bill, we're nearly out of time there. So thanks very much for joining us today. With just one last question. I'm a sole practitioner and I could only get one quote. When I go to the brokers, they're telling me that I have a quote already, so they're not going to quote me any further. Is there any way around that?
Go to another broker.
Go to another broker. And is it better to have an LLP or partnership rather than continue as a sole practitioner?
Well, again, that's a question of the limited liability. The advantage of LLP is that you limit your liability. As a sole practitioner, you have unlimited liability.
Listen, Bill, thanks very much for joining us today. Thanks everyone for joining us this week. Next week, we're joined by Richard Grogan to discuss social media tips. And the following week, we're joined by Simon Traynor to discuss just the different regulatory obligations between the Law Society and now the LSRA. And then we've Niamh Coonahan from Matheson is going to join us the following week to talk about this new Small Business Administration bill. So, Bill, thanks a million for joining us today. Slán agus gurmá agus.